who was described to us as an expert in the field of police policy and use of force. You also heard the expert testimony of Mr. Don Cameron, who was described to us as an expert in the field of police training, standards, and use of force. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge or experience may testify and state their opinions concerning such matters and give reasons for their testimonies. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment whether this witness's training and experience is sufficient for the witness to give the expert opinion that you heard. You must decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Impeaching a witness. A witness may be impeached by proving that the witness made some material statements out of court which are at variance with the witness's evidence on the witness stand. However, proof of prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of the matter asserted in such statements unless the trial judge has made those statements an exhibit. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard the witness's evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved on the trial. Criminal responsibility for the conduct of another. A defendant is criminally responsible as a party to second-degree murder, aggravated assault, acting in concert, aggravated kidnapping, official misconduct, and official oppression if the offenses were committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. A defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense or to benefit from the proceeds or result of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. Here, intent means that the person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it's the person's conscious objective or desire to engage in the conduct or cause the result. A person is criminally responsible for an offense committed by the conduct of another if, having a duty imposed by law or voluntarily undertaken to prevent commission of the offense, and acting with the intent to the benefit in the proceeds or the results of the offense, or promote or assist its commission. A defendant fails to make a reasonable effort to prevent commission of the offense. Intent means that a person acts or to a result of the conduct when it's the person's conscious objective or desire to engage in the conduct or cause the result. A defendant who is criminally responsible for an offense may be found guilty not only of the offense, but also for any other offense or offenses committed by another if you find beyond a reasonable doubt that the other offense or offenses committed were natural and probable consequences of the original offense for which the defendant is found criminally responsible, and that the elements of the other offenses or offenses that accompanied the original offense have been proven beyond a reasonable doubt. Deciding the criminal responsibility of each defendant, the jury may also take into consideration any evidence offered that a defendant attempted to thwart or withdraw from any of the offenses that followed from the original offense. To find a defendant criminally responsible for the acts of another, it is not necessary that you find the defendant was present or that the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of an offense is not sufficient to support a conviction. Before you
This business AI hack feels illegal to know about. It's like Canva, ChatGPT, Google Docs, and Midjourney all had
is not a separate criminal charge of the indicted charge or lesser included offenses. It is an alternate theory of criminal liability by which the state may prove a defendant's guilt based on the conduct of another person. Consequently, there is no separate verdict form for criminal responsibility. You will use the verdict forms for the offenses for which you find a defendant criminally responsible should a defendant be found guilty of any offense under this theory. It is not a defense that a person for whom's conduct the defendant is criminally responsible has not been convicted or was convicted of a different offense or different type or class of offense. Witness claiming to be a participant. The prosecution has presented a witness who claims to have been a participant with the defendants in the crime charged. While you may convict upon this testimony alone, you should act upon it with great caution. Give it careful examination in the light of other evidence in the case. You are not to convict upon this testimony alone unless you are convinced beyond a reasonable doubt that it is true. Limiting instruction. Members of the jury, you have received as evidence a memorandum of understanding, which has been marked Exhibit 4, and a guilty plea marked as Exhibit 16 of a charged co-defendant, Desmond Mills. You are instructed that this evidence may be only considered with respect to the guilt or innocence of the co-defendant for whom they belong. In other words, the evidence can only be used to assess whether the co-defendant is guilty or not guilty of the charges against them and cannot make any assumptions or inferences about another defendant in this case. Each defendant must be evaluated on the evidence presented specifically against them. The guilt or innocence of one defendant should not influence by a co-defendant's statements or any actions or statements attributed to them. You should assess the evidence against each defendant independently. Do not allow a co-defendant's statements to influence your judgment or deliberations regarding another defendant in this case. Evidence of good character. Evidence of good character has been offered on behalf of the defendants Tadarius Bean and Justin Smith. This is to be considered by the jury along with all the other evidence in the case to determine if there is a reasonable doubt about the defendant's guilt. A person of good character may violate the law, but a person of good character is less likely to violate the law than one of bad character. If you find the defendant's character to be good, such may be considered for purpose of strengthening his presumption of innocence. If you find the defendant's character to be good, it may stand as a witness on his behalf, and you should consider it along with all the other evidence in determining whether the defendant is guilty or not guilty. Defendants not testifying. The defendants, Tadarius Bean, Demetrius Haley, and Justin Smith, have each not taken the stand to testify as a witness, but you shall place no significance on this fact. Each defendant is presumed innocent, and the burden is on the state to prove the defendant's guilt beyond a reasonable doubt. No defendant is required to take the stand on his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Cause of death. Before a defendant can be convicted of any degree of homicide, the state must have proven beyond a reasonable doubt that the death of the deceased was proximately caused by the criminal conduct of the defendant, by the conduct of another for whom the defendant is criminally responsible, or both. The proximate cause of death is that cause which, in a natural and continuous sequence, unbroken by independent intervening cause, produces the death, and without which the death would not have occurred. A defendant's conduct need not be the sole or immediate cause of death. The acts or omissions of two or more persons may work concurrently to proximately cause the death. In such a case, each of the participating acts or omission is regarded as a proximate cause. It is not a defense that the negligent conduct of the deceased may have been a proximate cause of the death. However, it is a defense to homicide if the proof shows that the death was caused by an independent intervening act or omission of the deceased or another, which a defendant in the exercise of ordinary care could not reasonably have anticipated as likely to happen. However, if in the exercise of ordinary care a defendant should reasonably have anticipated the intervening cause, that cause does not supersede the defendant's original conduct, and the defendant's conduct is considered the proximate cause of death. The sequence of events or the particular injury doesn't need to be foreseeable. It's only necessary that the death falls within the general field of danger which a defendant should have reasonably anticipated. If some other circumstances cause the victim's death unrelated to the defendant's action, that would be a defense to homicide unless the circumstances was the natural result of the defendant's acts. There is evidence in this case that the deceased required medical attention as a result of injuries that may have been unlawfully inflicted by a defendant, and that such treatment itself may have contributed to the death of the deceased. If you find this evidence to be true, then you must determine whether the medical treatment is of such a character as to relieve the defendant of the responsibility for the death. One who unlawfully and seriously injures another to the extent that medical attention is required bears the risk that improper treatment may result in death of the injured person. If a defendant unlawfully and seriously injures the deceased, he is not relieved of responsibility unless the treatment was performed in a grossly negligent and unskillful manner, and unless it was the sole cause of the death. If you find that a defendant's acts, if any, did not unlawfully cause or contribute to the death of the deceased, or if you have a reasonable doubt about this proposition, then you must find the defendant not guilty. Jury notes. Members of the jury, the court charges that if any of you have been taking notes in this case, that these notes are for your individual use only, and that you should not use your notes directly or indirectly, explicitly or implicitly, to persuade other jurors as to the accuracy of your notes. It should not be shown to others, nor compared, nor referred to in any way as authority, but should be used privately only by you as an aid to your individual memory. Multiple counts, finding on each required. The crime charged in each count of the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your findings as to each crime charge must be stated in your verdict. Unanimous verdict. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Deliberation. Order of consideration as to defendant Tadarius Bean, Demetrius Haley, and Justin Smith. In deciding your verdict for each count, you shall first consider the offense charged in the indictment. If you find the defendant guilty of that offense beyond a reasonable doubt, you should return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense, or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in the order from greatest to least within each count of the indictment. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense charged in the indictment. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count of the indictment, you shall return a verdict of not guilty for that count of the indictment. Verdict form, count 1, second-degree murder. We, the jury, find the defendant Tadarius Bean, only checking one box. First charge for your consideration, the indicted charge, guilty of second-degree murder. Lesser included offenses in the order of consideration, should the jury find the defendant guilty, would be facilitation of second-degree murder, guilty of manslaughter, guilty of facilitation of voluntary manslaughter, guilty of aggravated assault resulting in death, guilty of facilitation of aggravated assault resulting in death, guilty of reckless homicide, guilty of facilitation of reckless homicide, guilty of criminally negligent homicide, guilty of facilitation of criminally negligent homicide. If the jury has a reasonable doubt as to the indicted charge or any lesser included offenses, the jury is to select not guilty as charged in the first count of the indictment signed by a jury foreperson. The same instructions with regard to count 1 with regard to the defendant Demetrius Haley. In the following page, the same instructions with regard to count 1 for the defendant Justin Smith. Verdict form count 2, aggravated assault acting in concert. We, the jury, find the defendant Tadarius Bean. Again, only check one box. The indicted charge, guilty of aggravated assault acting in concert. The lesser included offenses in order of consideration, guilty of attempted aggravated assault, guilty of facilitation of aggravated assault, guilty of reckless aggravated assault, guilty of facilitation of reckless aggravated assault, guilty of reckless endangerment, guilty of assault, guilty of attempted assault. Should the jury have a reasonable doubt as to the indicted charge and the lesser included, the jury is to select not guilty as charged in the second count of the indictment signed by jury foreperson. Same instructions apply on the following page to the defendant Demetrius Haley. On the following page, the same instructions with regard to count 2 for the defendant Justin Smith. Verdict form count 3, aggravated kidnapping with bodily injury. We, the jury, find the defendant Tadarius Bean. Again, check only one box. The indicted charge, guilty of aggravated kidnapping with bodily injury. The lesser included offenses in order of consideration, guilty of attempted aggravated kidnapping, guilty of facilitation of aggravated kidnapping, guilty of kidnapping, guilty of attempted kidnapping, guilty of facilitation of kidnapping, guilty of false imprisonment, guilty of attempted false imprisonment. Should the jury have a reasonable doubt as to the indicted charge or any of the lesser included offenses, it is to select the not guilty as charged in the third count of the indictment signed by the jury foreperson. The same instructions apply on count 3 with regard to the defendant, Demetrius Haley. On the following page, with regard to count 3, the defendant, Justin Smith, the same instructions apply. With regard to verdict form, count 4, aggravated kidnapping with a deadly weapon, we, the jury, find the defendant, only check 1, the indicted charge, guilty of aggravated kidnapping with a deadly weapon. The lesser included offenses in order of consideration, guilty of attempted aggravated kidnapping, guilty of facilitation aggravated kidnapping, guilty of false imprisonment, guilty of attempted false imprisonment. Should the jury have a reasonable doubt with regard to the indicted charge or any lesser included offense, it is to select not guilty as charged in the fourth count of the indictment signed by jury foreperson. The same instructions apply on the following page with regard to count 4 and the defendant, Demetrius Haley. On the following page, the same instructions apply to count 4 with regard to the defendant, Justin Smith. Verdict form, count 5, official misconduct, unauthorized exercise of official authority. We, the jury, find the defendant, Darius Bean, only check 1 box. The indicted charge be guilty of official misconduct, unauthorized exercise of official authority. Lesser included offenses in order of consideration would be guilty of attempted official misconduct, guilty of facilitation of official misconduct. Should the jury have a reasonable doubt as to, with regard to the indicted charge or any of the lesser included offenses, it is to select not guilty as charged in the fifth count of the indictment signed by jury foreperson. The same instructions apply on the following page, verdict form, count 5, with regard to the defendant, Demetrius Haley. The same instructions apply on the following page, verdict form, count 5, with regard to defendant, Justin Smith. Verdict form, count 6, official misconduct, refraining from performing a duty. We, the jury, find the defendant, Darius Bean, only check 1 box. Indicted charge is guilty of official misconduct. Lesser included offenses in order of consideration would be guilty of attempted official misconduct, guilty of facilitation of official misconduct. Should the jury have a reasonable doubt as to the guilt of the defendant on the indicted charge or any lesser included offenses, it is to select the not guilty as charged in the 6th count of the indictment. On the following page, the same instructions apply to count 6, verdict form, with regard to defendant Demetrius Haley. On the following page, verdict form, count 6, the same instructions apply to defendant Justin Smith. Verdict form, count 7, official oppression. We, the jury, find the defendant, Darius Bean, only check 1. The indicted offense, guilty of official oppression. Lesser included offenses in order of consideration, guilty of attempted official oppression, guilty of facilitation of official oppression. Should the jury have a reasonable doubt of the defendant's guilt with regard to the indicted charge or any of the lesser included offenses, the jury is to select not guilty as charged in the 7th count of the indictment signed by the jury foreperson. Verdict form, count 7, the same instructions apply with regard to Demetrius Haley. On the following page, verdict form, count 7, the same instructions apply with regard to defendant Justin Smith. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. If a question arises during the deliberations, first go back and review your jury instructions, as the majority of your answers to the jury questions are found in there. If the question remains and or you need further instructions, please print your question on a sheet of paper and have the foreperson sign it and give to the deputies. I will read your question, and I may call you back into the courtroom to try to help you. But more times than not, the court's answers will be to look back at your jury instructions. Please understand that I may only answer questions about the law, cannot answer questions about the evidence. You will write your verdict clearly as to the indictment on the inside of the jacket as instructed on the previous pages, and have one of the names of the sign as the verdict on the verdict as foreperson. Take the case, consider all the facts and circumstances fairly and impartially, and report to the court such verdicts as truth dictates and justice demands. Now, ladies and gentlemen, you have now received the law. You've heard and received all the proof, yet it's still not time for the deliberation. Now, we are going to take just a brief recess to allow you all to step out so we don't have any interruptions while we go through the closing arguments. But please make sure you do not discuss the cases. You can leave your notebooks and those bindings in your chairs. We're just going to take a brief recess.
Jury may be excused for a recess.